Okay, then I'll start. So, before begin on the next lesson, do you have any questions relating to the lesson one? Anyone? No? So, anyone did their research on the exclusivity clause or non-compete clause? No? Okay, great. Okay, then I think we should move to the second one. I still suggest that you start reading because unless you do reading, you won't be able to write. So it's important that you read also and read quite a lot. Take some time, half an hour day, read it on your mobile, read something relating to contract drafting. It can be anything, but do start it. Okay. So, moving to lesson number two, we will be discussing the categories of contract language. So, what are these categories? Uh, Basically, categories means the type of words that we use to create certain types of obligations or to make suggestions or to record an understanding between the parties. So that's categories of different types of languages that we do, and these languages help us in structuring the contract in a way that should be acceptable to the other side. In case a specific obligation is not acceptable, then we can reword it. So I'll tell you how to do that. So, what are these categories? There are different categories, of course, but for the purposes of today's discussion, I have kept it limited to the rights and obligations, covenants, which are also another name of for obligations, declarations, intentions, recommendations, conditions, prohibitions, policy statements, and discretion. There are additional categories like representation and warranties, but these will be discussed in lesson number 5. So we'll understand these categories in detail in next slides. You may have studied about rights and obligations being part of every contract. What these rights are. So basically, a right is something that you, as a party, can claim against the other. You can exercise that right, enforce that right, and the counterpart of a right will always be an obligation. So, for example, if I ask to you that you have to give me something, so that is an obligation on you, and I'll have a corresponding right to receive that something from you. So, right and obligations are always interlinked. There cannot be a right without an obligation, and vice versa. So, it is important to specify the right or the obligation depending on the context. In some places, you can specify an obligation, but in some places, it's better to uh, include a right rather than write it as an obligation. So, let's see some examples. The first statement is that buyer has a right to purchase the shares from the seller. Second one is buyer reserves the right to purchase the shares from the seller. Now, both these statements are quite different. The first statement is a clear right, and the second is an option. It is an optional right or an optional obligation, you can say. It is not a clear cut right. So once you say the buyer reserves the right, so that means he can or she can exercise that right or not exercise that right. The subject will always have a right against the object, that is the other party. So the buyer is the subject and seller is the object. But in the first statement, it doesn't specify the obligation, it only talks about the right. So you have to think carefully whether you want to create a statement which is an obligation or a right. So it is better to write that the seller undertakes to sell these shares to the buyer on so and so date or on satisfaction of certain conditions. Because enforcing an obligation is always better and easy than enforcing a right. Now, what these obligations can be. So, in the next slide, we have just reversed the statement that buyer shall purchase these shares from the seller on so and so date. Again, the second statement is buyer agrees to purchase the shares from the seller on so and so date. These two statements are quite different with different meanings. One puts a clear obligation. The second one, although it puts an obligation, but it is not very specific. It is just an agreement to purchase. So there may be case of a memorandum of understanding where you will have the second statement. But if you have a share sale agreement, you will include the first statement. The right corresponding to these obligations will be that we discussed just in the first slide. So you may have heard of a clause known as right of first refusal. So let's say a party is entering into a contract with another where one of the parties investing in the other party's business. So let's say they buy 25% of the shares, outstanding shares of the second party, and by doing that, they give some amount for share subscription. Now, because of business conditions, the second party decides that they want to sell the business and they have a offer from a third party. So, in the share subscription agreement or the agreement between the two sides, there will be a clause of right of first refusal, which will be in terms that the second party, if he ever decides to sell the shares that he has, then he will offer those shares first to the first party. Or there may be a condition attached to it that he can offer it to the third parties in general, and the first party will have the option to match that so that the second side gets a better deal. This is also found in lease agreements. So, for example, if there is a long term lease, then instead of giving the owner a right to sell the property, there will be a right for the lessee to buy that property from the lessor if he ever decides to sell that. The example that we have here in the slide, it's a lengthy clause, but if you look at the language, this is a right of first refusal in a lease agreement. So it says that if during the term of the lease, lessor, if there is a bona fide offer to purchase all or part of interest in lease premises from a third party, or they desire to sell the or dispose of such interest, then they shall notify the lessee about informing them about the party to whom they are going to sell this. property, and the price and the terms on which it is going to be sold. And within a certain time frame of 30 days, the notification has to be reverted back by the lessee whether they want to purchase such interest on the terms which are agreed with the third party or under discussion with the third party. If the lessee elects to purchase, then the lessor is bound to transfer that interest to the lessee on the same price and on same terms. And if the lessee chooses not to exercise that right or fails to give this notice, then lessor can freely transfer those rights to the third party. However, it should not be less than the price stated in the notice. And there is additional clause that even if they sell, that will be subject to the terms of lease, and that there is a limitation that if they do not exercise the right of first refusal or after expiry of 30-day period within which they have to give the notice, then that will apply to the disposition by lessor of any such interest. Now, this is second clause which is not relevant for our discussion. Any questions on right of first refusal? Okay. So, as I stated earlier, we have to think whether we should have a statement which is in form of a right or whether we should have an obligation which should be in form of a statement in form of an obligation. Now, I want you to think about a situation, for example, a license agreement, license for trademark. So, in that case, you want to place a restriction on the licensee that they have to use the license with respect to certain goods and in certain territory. So, what that statement will be? Will it be in form of a right or will it be in form of an obligation? So, without waiting for your answers, it will be in form of an obligation because you are restricting someone from exercising a right in a particular manner. That's why you have to have this kind of restriction in form of an obligation. So, you will say that the licensee shall exercise the right or exercise the license for the trademark with respect to XYZ goods only in ABC territory and no other. Covenants. So covenants are what? Basically, they are nothing but form of a duty or an obligation. So these are the another name for duty or an obligation. So, same way it is a promise, it is to do something or not to do something. Now, in some old format agreements, it is standard to write that party A covenants as follows, and that will then list out certain covenants. Now, instead of saying that party A covenants, we can simply list those statements that XYZ shall do something or shall not do something. So we can use the exact obligation. So covenant is a old format which we can avoid. Next is declarations. Declarations are statements of fact that parties will agree to, and they are most of the time used for declaring the definition. So it will have a language like buyer means party A, seller means party B, property means the party demarcated or having address this. They themselves do not create any rights and obligations because there is no promise built into them. So declarations are something that you have to ensure that they are not written in form of any right or obligation. Now, similar to declarations, there's intention. Now, intentions are declarations reflecting parties' intention, and they are commonly used in the recital part of a contract. For example, the buyer desires to purchase raw materials for its plant, and the standard way which old contracts show that these kind of statements are often clubbed with representations. So it can be in form of that buyer desires to purchase raw materials for its plant, which the seller has offered to supply to the buyer on following terms and conditions, or seller has represented to buyer that it has the resources to supply the raw material and has offered to supply these to buyer on following terms and conditions. So these kind of languages are limited to recital clauses, and they should not be used in the main body of the contract. Additional suggestion will be to avoid clubbing this kind of language by with the representation or warranties. They should be covered as separate section in a contract. Next is recommendations. Recommendations are suggestions made in the contract. These recommendations uh, can be very rare. So, for example, let's say if there is a test, technical test that needs to be conducted, then there can be a suggestion or recommendation that the contractor will get the technical test conducted by a reputed testing agency in India. It can be a reputed testing agency having experience in XYZ field, but it is always suggested to change a recommendation to a condition. And instead of saying that it is advisable, we can simply say the contractor shall get the technical test conducted by XYZ agency in India. Conditions. Conditions are qualifying statements that is something to be done, or usually these are linked with an obligation. So instead of saying that contra the suggestion language, we can use the revised one. The contractor shall get the technical test conducted by XYZ agency. So in this example, the XYZ agency doing the test is the condition. It can also be a case where, uh, for example, in share sale agreement, the conclusion or execution of share transfer agreement will depend upon closing of certain preconditions. Those preconditions can be like due diligence or grant of loan if you're buying a property by the bank. So those conditions are interlinked with the obligation of a party. Unless those conditions get satisfied, the conditions, the corresponding obligation to the condition do not get triggered. So it is important to ensure that conditions are clearly defined, what those conditions are, and if they do not get triggered, then what will be the consequence. So you also have to think about that. For example, if you're going to buy a flat, then in that case, if it is a condition that the bank should grant a loan, and if bank doesn't grant a loan, then the buyer can opt out from that sale agreement. But then there can be a qualification that if because of incomplete documentation on the buyer's part, bank refuses to grant the loan, then they cannot exit. Then they have to pay certain penalty and then they can exit. So we have to think carefully how to use the condition, and if we are using a condition, then what will be the consequence if that condition is not satisfied. Then we have prohibitions. Now, these prohibitions, restrictions, or limitations can be associated with right. For example, we just discussed the license agreement. So, we can limit the exercise of right of use of trademark in the territory, a particular territory, or in a particular manner or medium. For example, you can grant the license to a distributor to sell the product only through offline medium or only through online medium. So that kind of restriction can be used. Next is a policy statement. So do not get confused about policy statements. These are simple declarations. They do not create any rights and obligations. They are generally used to state a governing law. For example, this agreement shall be governed by the laws of India. So this is kind of a declaration or a choice of the parties. Then there is a language of discretion. Discretion is again an optional choice. It is not creating any obligation who has this option. So, for example, if there is a agreement where you are, for example, in the distribution agreement, you are allowing the distributor to sell the products in a certain territory, but you are not sure if they are meeting the targets, keeping the records, then you can have an option to audit the financial records of the contractor. In that case, contractor may argue and ask for limiting this option to the contract transaction itself and not a general financial record audit. So it will be limited to the transactions of the contract. Moving on, we will discuss a contract. We'll randomly pick a contract and we'll discuss these contract categories. Now, there is a recommended reading material. This link I have shared today in the group and also by, I think, email maybe. And there is also a book. So, these, if you get a chance, do read it. There is also a video link which discusses this entire thing in quite detail. There will be some overlap uh, in how to structure that, but the idea behind this lesson was to give you an understanding of how to use a specific type of language, whether to create an obligation or a right, whether to have a declarative statement, whether to have a discretionary statement, whether to have a choice, or whether to have it as a policy statement or neutral statement. So now that you have an idea, we'll move on to the discussions. And before moving, uh, just give me a second.
Yes.
Okay. So this is a distributor agreement with minimum purchase obligation. This is quite an old one. A US based organization, Skull Candy, is appointing a distributor in Sweden. Now, the background that we have here is that the Skull Candy, as we know, is a quite reputed organization and they want to put a limit on the distributor to have the ability to buy certain minimum quantity. Now, important terms are covered in the initial part. Who is the company? Who is the distributor? What is the recital here? So, reputation and abilities. Now, companies, representation and warranties. that the company has certain proprietary products. Then there is a reputation attached to those products and some trademarks and logos. So those trademarks and the company holds a value in these and there is a goodwill of the company. Now distributor also represents that they have finances, employees, resources, etc. to distribute the product in certain territory, and they will do so in good faith, and they will not damage the name, reputation, goodwill of the company or the trademarks, and they will maintain the name and goodwill of these trademarks and products. The territory is Europe. The market is retail, wholesale, online, catalog, and direct response. The term is fixed for 3 years with a 36-month notice period, and there is a termination provision. The terms of sale is FOB factory, payment terms by the factories to company shall be extended to distributor. Then there is minimum purchase volume year-wise, and there is also uh, segregation of uh, how these purchases shall be made. Now let's move to the actual contract, the terms and conditions. Now these are definitions used in the contract which will be applicable to this distributor. There is a definition: company trademarks shall mean each of the trademarks so and so, etc. Now, this is not an obligation, it is just a declaration. Distribution proceedings shall mean so and so thing, government agency shall mean so and so, person shall mean so and so. So, these definitions all are in declarations. Now, there is a appointment. Now, this statement, read it carefully. Subject to the terms and conditions of this agreement, company hereby appoints distributor. Now, this is neither a right, neither a obligation. But it goes on to say during the term as company's exclusive distributor in the territory of the products for distributor's distribution to its customer in the territory for their sale only in the territory, and distributor hereby accepts such appointment. So once the statement is given that what this distribution is all about, then it is closed with the statement that distributor accepts this appointment. So they are accepting it and creating an obligation on themselves that the appointment of distributor is on these conditions. Now they have certain rights also, like distributors shall be entitled to appoint sub-distributors. Such consent shall be granted within 5 business days, shall not be unreasonably withheld, and distributor shall impose the relevant obligations contained in this agreement on its sub-distributors. Now, the last statement is a condition as well as an obligation. Now, they have to impose similar obligations for their distributors. So, the right of distributor getting this appointment or the obligation is conditional upon the fact that if they appoint the sub distributors, then they have to have similar obligations in the contract with them. Now, let's see 2.3, no distribution outside territory. Distributor hereby agrees not to do any of the following directly or indirectly: sell or solicit the products outside the territory, uh, modify the products without the consent of the company, or distribute the products in other than company's original packaging or without the company's trademark, without the consent of the company. So these conditions create an obligation, and distributor, by saying that he hereby agrees not to do so many things or these things, is assuming an obligation. So these conditions clubbed with the obligations become a clear statement what distributor is expected to do. Now, as we discussed the inspection or the audit clause, similar to that, there is an inspection clause. In order to ensure distributors' compliance with the terms of this agreement, distributor hereby agrees the company shall have the right, at company's expense, to inspect at reasonable times, either itself or through its duly authorized representative, all or any portion of distributor's facilities with regard to use of the products, confidential information and company trademarks, storage, marketing, sale and distribution of the products, and distributors' compliance with this agreement. So it's a very wide right that the company reserves for itself and distributor agrees to such right. So it's a combination of the right and obligation which creates this statement. Now, stopping the further discussions, what you understood by these kind of statements may not hold true always. So sometimes you may be able to have this kind of clause because you are drafting the contract. So you will be able to create the contract with clear language. But sometimes you will get a, for example, if you're getting appointed as a distributor, then you have to see that what rights company is reserving for itself and whether it needs to be qualified. For example, if they are reserving the right to inspect, then it has to be on a reasonable time. They have to give some advance notice for that. If they want to inspect, it has to be at their own cost. So these things have to be covered. Now, if you have any questions on any of the points that we discussed today, then you can ask me now. So I'll give if all of you, because you are not voluntarily asking the questions, so I'll ask one by one. Anshuji, do you have any questions?
No, so nothing from my end.
Okay, Anshuji. So, I mean, I want to hear from you uh, a statement or a clause on the term of, let's say you have to define the term of an agreement. So, how you will do it? What you will write? You can freely say anything because it's just a learning exercise. There is no wrong, no right. Whatever comes to your mind, you can say. A simple statement saying what will be the term of the agreement or duration of the agreement.
This question is only for Anshu, or it is open for everyone, like anyone.
Uh, it is open for all, but Anshuji should answer first.
Okay.
Anshuji, any comments? Yes, no, any difficulty in understanding the question? If you want to learn through this class, then you have to participate. So even if you are unable to say something, just say that you are unable to say something so that I can move to next one.
Sir, can you repeat the question?
It's a very simple one. If you have to write a statement saying define the term of the agreement, duration of the agreement. So what that statement will be, how you will write it.
It could be that the term of the agreement is whatever, it's gonna start at this date, the commencement date you can write, and the date when it's going to, like it's going to get over.
Yeah,
So it could be in years or whatever months that we are
just give me
agreeing
one
to.
simple statement, the exact clause that you want to say.
Um, I can't think of any particular statement as such.
Okay. So let's say, can it be that the term of this agreement shall start from the commencement date and shall remain valid for a period of, let's say, 1 year. Is it okay?
Yeah, yeah, correct, correct.
Right. So in this statement, what kind of language is used? Is it a right, an obligation, policy, declaration, discretion? What do you think it is? It can be wrong answer also. No problem with that.
Sir, it's a right because we are agreeing on to it, like both the parties have agreed, so it could be a right.
Okay. Now whose right it is? As you said, both parties are agreeing to it. So is it a right for both parties?
Yes, sir, both.
So what is the corresponding obligation? Because all rights must have obligation attached to them.
Sir, it is the right for the licensor in case of licensing agreement, and it is
Govinji, I'll put you
sorry,
on.
sorry.
I'm so sorry. I understand your eagerness to answer, but it's an opportunity for Anshuji. Let her answer. What do you think, Anshuji? What will be the obligation? Or can you think that it doesn't have any obligation?
No, so yeah, as Govind said, I mean, it could be the first party. If it's the licensor, then that person would have the right, and the other party
Let's say it's a
who's
sale agreement.
agreeing along with him.
Let's say it's a service agreement, it's not a license. See, as a lawyer, you have to think many things. You cannot limit yourself. You have to be very creative. You have to be very open-minded, and you have to think out of the box. So it cannot be limited to a license agreement. Can it be said if there is a service agreement, will the obligation be same? And if yes, then what that obligation will be?
So if suppose a statement which states that a buyer shall purchase,
No, no, we are only discussing
so
the
it creates.
term clause. You said the term clause is a right of both parties because both parties are agreeing to it. So
Yeah,
what is,
correct.
yeah, so the obligation, what is the obligation?
So I don't know.
Okay, so RPG, now you can help this. Is it a right?
Okay. Hmm. uh, so can you just repeat the clause?
Yeah, the
Like
clause is,
was
uh,
stated.
yes, yes. This agreement
Mhm.
shall commence from or become effective from the commencement date and shall remain valid for a period of 1 year thereafter.
Okay. Okay, so basically in this clause, this is neither a right nor a obligation because they are not putting any obligation in this clause. I believe they're just saying this is the term of the agreement. Like this agreement will be valid for 1 year and it will renew for another year. That's it. So
So
this is not
what
adding any.
so it qualifies under what category of contract language?
So this is um, under declarations.
Thank you. So you understood it right. It is a declaration both parties are making that this agreement shall become effective from so and so date and shall remain valid for so and so period. Now, there is no right attached to it, there is no obligation as such, but the way it is written, it is understood that in case a party wants to enforce this agreement beyond the term of the contract, they cannot do it. So, there is a hidden right for a party to escape from any responsibility under the contract after expiry of term. And there is a right of a party to enforce the terms of this agreement during the validity of this agreement. Now, those rights will have a corresponding obligation. So, in the first case, if a party chooses to enforce this agreement after expiry, then there is an obligation on that party not to enforce because the contract has terminated. They cannot exercise this right because it will be beyond the scope of the contract. But within the validity, if they are enforcing the terms of this contract, then the corresponding obligation of the other party is to honor the commitments made under the contract. Thank you so much, Aditi, for your insight. Anup ji, do you have any question? Are you unable to say? Okay, no problem. You can go through the video recording and maybe come back with your questions. Aarti ji, do you have any questions? Any questions, Aarti ji?
Oh, I'm so sorry. I was on mute and I was just talking and
It's
talking.
all right. It's all
Okay. So I just wanted to know because this is something this always comes to my mind, and while whenever I'm reviewing or negotiating any agreement, I'll make sure I'll keep this particular word in my mind. That is shall,
right. Hmm.
because I have a habit of using will and may more as compared to shall, because I believe this is what I understood. This is my understanding, and I just wanted to know, like, okay,
Okay,
whether it is actually like the right approach, or we can use other words as well.
we
So, with
can
regards
we
to,
can use
yeah,
other words as well. Okay,
no,
that's a
no. So here
yeah.
the question is with regards to shall.
Hmm.
Generally, I use shall word whenever I want to force some kind of obligation, like where I want to be sure, like okay, this should not be an option, and this should not the other party should not bypass this thing. So that time, while phrasing the clause, I'll use shall. So, and when I was like, okay, there's an option. When I feel like, okay, there is an option to choose, then I'll go ahead with the uh, may or will. Shall be instead of shall be, I'll go ahead with the will and maybe. Will be maybe. So
Have you ever
I just,
used must?
yeah, I must as well. Yeah.
Okay, okay. So
Like in some areas, like it's like must comply all the terms and conditions. So,
interesting. Okay, so it's a very valid question because we lawyers have misused shall a lot. There is a lot
mhm.
of discussion among legal fraternity, and there is a very good article. I think I'll have access to it, so I'll share that with you and all of you. So, if we understand the English language, because everything written in English language should be construed as the language is expected to be understood by others. Now, when I say I shall, okay, or you shall, then it is fine as per English language. But when I say he shall instead of he will, then I am creating a clear obligation on he or she, or they shall instead of they will. Then I'm creating a clear obligation.
Mm-hmm.
Sometimes we can use clever wordings like instead of using shall, we can say that what that actual requirement is. So instead of saying buyer shall do XYZ things, we can say buyer agrees to do so and so thing by this date. Or we can remove the subject and object in personal mode. For example, in payment clause, we can say that the release of payment is conditional upon the payer receiving the invoice copy from the seller. So those kind of languages can be used. But shall is very often used, must is rarely used, may is also rarely used, and will is generally used where you don't want to create an obligation, but you want to have some kind of understanding. So I'll be doing that, you will be doing that. Even if you're saying it is will, even in those cases, it will be considered as a valid obligation. Because if I say the buyer will do so and so thing, and seller will do so and so thing. So now, if you take the English language, it is not putting an obligation, but it is saying that it is something which will happen in some future date. But if you speak legally, whether you use shall or will, it doesn't matter. It is how the contract has been written, how it is construed by the parties, how the courts will view in case of a dispute. That is very, very important. So, this is my understanding of it. I use shall most often in all my clauses. So, you can safely use shall, but some modern authors, and one of them is an authority in US who is now thinking out of the box and changing the way we draft contracts. His name is Ken A. Adams. The article on categories of contract that I referred, it contains some additional sub part of that, and you can read that PDF and you will find that if you are writing a right, then how you should write it. If you are creating an obligation, how you should write it. He has suggested the language how it should be written. So go through that PDF. It is a very helpful one and you can keep it as a reference point. But if you're using it more often, then expect that the other side will counter that because they are basically following the set pattern. They don't want to be wavering for that from that set pattern. So you have to argue forcefully why this kind of language you are asking for. So that's a very helpful PDF. You can use that as a reference document.
Okay.
Any other question?
No, okay. So once I'll read that
Yeah, please do. Please do.
article, then maybe
Yeah,
I'll get back to you
I'll
with
also
questions.
share some articles so you can yourself do some research on difference between shall and will in contract
Sure.
language. So that
Because
will you can find many things.
as of now, what I'm doing, like while I'll make sure, okay, I'll make sure, like I'll use that shall word in indemnity and LOL clauses so
No,
that there
my
should be an
suggestion to
obligation.
you will be don't
Yeah.
follow something blindly because somebody said so. Apply your mind why you want to do that. And you have to have the conviction inside you why you want to use shall or why you don't want to use shall. So those conviction has to be based on reasoning. That reasoning will come when you are reading something on that, you're getting some ideas and you can explain those ideas to the other side. You can convince the other side. So even if you write shall and if the other party doesn't want to agree to that, then you have to convince him why you want that and why he doesn't want that. So it is a very balancing act. So as a lawyer, I think every day we have to think in a different manner, and we have to convince not only ourselves and others also. So before you convince others, start convincing yourself first why you want to do that.
Mhm. Sure. Thank you.
Thank you. Govindji, coming back to you. Any questions?
Hello.
Yeah, Govindji.
Yeah, no questions as such, sir.
Okay.
Now,
So you
for now at least.
okay, but I don't want you to go so soon. Can you help us with a discretionary statement
Please explain further what kind of discretion is this?
in a contract? What clause will have a discretionary language? You want to have some kind of discretion. So what that kind of which type of clause you think will have a discretion? If you remember, we discussed the audit clause or inspection clause, where we said that
Yeah,
a party may audit the other party or has a right to audit the other party, but has no obligation to do so. So at its option, it can do so, and it is optional thing. So what do you think? There can be another situation where this kind of language can be used.
yeah,
While you think on that, let's move to Noshin ji.
okay.
Noshin ji, same question for you.
Okay, so according to me, I believe termination clause should be a discretionary.
Can you give an example?
For example, generally what happens is when we are entering into a business sale, the seller has the authority to terminate the contract in case the buyer violates any of the terms and conditions of the agreement without prior notice.
Okay. So you are saying that in case,
And whereas the buyer,
hmm sorry,
yeah, yeah,
go ahead, go ahead.
okay. So whereas the buyer will have to give a notice, prior intimation, in order to conclude or cancel the agreement.
hmm So are you saying that, let's say, if there is a breach by the other side, then by giving the notice, the non-defaulting party can terminate the agreement, and this kind of language is a discretionary agreement. Okay. Don't you think this is a conditional statement? Because there is a condition that if there is a default or breach, then only that notice exercise can be done.
Yeah, like I thought like full
Yeah.
justification is given to a seller,
Arti,
so
Arti
for
ji has
breaching
some
this kind of
suggestions on this.
agreement.
Yeah, Arti ji, go ahead.
Yeah, so I would like to add here, this is regarding the termination, but instead of in case of default, for convenience, we can consider it as a declaration, because like either party may terminate this agreement for convenience at any time by giving like 15 days, 30 days, 10 days notice.
Yeah, that's right. Thank you so much. So, Noshinji, I hope you understood. If it is a conditional termination, for example, breach, non-payment of, let's say, invoices for a certain period, those terminations will be a conditional statement. But if an exercise of termination is based on convenience, then that is something is a discretion, and those kind of discretion is allowed in some of the contracts, but they are not allowed in contracts like EPC contracts because there is a fixed period to complete the project, and once the parties enter into in the contract, there is a lot of money at stake, so this kind of language may not be there. So we have to understand if the discretionary language in a certain clause can be included or cannot be included. Thank you, Noshinji. Govindji, have you been able to think of something else? So I think Govindji will take some more time. Noshinji, thank you. You can put your mic on mute. Prathamji, do you have any questions?
So I was just wondering, like we use the shall clause for shall words to create obligation.
Mm-hmm.
Is it possible in some contracts or like people do that they use obliged to, like the distributor is obliged to do this or hire some other people? Can we use obliged to in place of shall?
Yes, yes, why not? See, if you don't want to say that distributor shall comply with these conditions, so you can instead say distributor is obliged to comply with these conditions. So that kind of language is very clear that it is creating an obligation. So when you're saying obliged to, so it is understood that there is an obligation on the distributor. So it is fine with that.
Also, sir, you were explaining earlier that thus the that clause the agreement shall commence from commencement date and shall remain valid for 1 year thereafter. This clause.
Hmm.
You said something there that the rights and obligations are hidden in this. I missed that certain parts. Could you please repeat that part?
Sure,
That
sure, sure. So basically, if there is a contract which is valid for a certain period, then it is implied that the parties' rights and obligations of that contract can be enforced during that validity period only, not after the expiry of that validity. So, if the agreement is expired, the rights and obligations cease. In that situation, if somebody comes, then there is no right and obligation surviving. But if there is, let's say, uh, any fraud or let's say mismanagement during the contract, then they have a legal right to enforce those compliances. So, for example, there is a underpayment, and the contractor says that I have executed this much of work, but you have paid me only 20%. So, they can go into a dispute under the arbitration clause, which survives the validity of the contract, and then they can enforce that right. So, what we discussed earlier was if there is a contract during the validity, there is a right, there is an obligation. It can be anything under the contract. There are certain clauses which survive the validity. So, those rights and obligations, for example, arbitration clause, for example, indemnity clause, for example, audit clause. Some another example would be a warranty on the product because there can be a contract for supply of goods, but there can be a extended warranty beyond the validity of supply agreement. So those kind of situations, there will be a right surviving after the termination. Yeah, Govindji, are you ready
Yeah,
now? Yeah,
yes,
thanks.
sir. In case of subscription of a website or certain website which offer certain kinds of uh, services. So, so they offer free trial services for first 30 days or 15 days. So during which they also mention that if the consumer if the customer wants, then they may cancel the service and no payments will be charged from them.
mm,
So it's kind of a discretionary right on the part of a customer,
mm.
that if that at their will they can cancel this subscription.
So, do you think it's an option for the
Yeah, it is
customers?
yeah, it is absolutely optional
Hmm.
or absolutely discretionary.
Yes,
Uh,
yes. So you are right. So the discretion lies with the customer, but it is a, I mean, short-term contract. So, for example, if the condition of going beyond the initial offer period is over, so let's say if they are giving 30 days trial period, after that trial, the customer chooses to exercise, then it becomes an obligation on the customer to agree to certain other terms which will with regards to use of that software or website or application. But if they are using for a trial period, then there will be a separate terms for those trial. Now, as a lawyer, you have to understand that if there is a website or a software developer who is your client and they're offering such terms, then you have to have a separate clause for the trial period. Okay. So there is something that you have to keep in mind. So when you are drafting a contract, you are not just thinking of what your client has said. You're not thinking of what the other party has said, but you are thinking yourself also that what those situations can be. Do we need a term for those situations? How we protect our client, whether in our effort to protect our client, whether the other side will accept that clause or not. If they will not accept, to what extent they will accept. All those things also have to be thought. So it is not something that you have to think on day one. It's a progressive exercise. But do not stop thinking. Do not stop analyzing. At each stage, do not think that this is everything that you can do, because there will always be something more that you can do. So, as a contract drafter, you have to keep using and keep learning and keep revising yourself. Thank you so much, Govindji, for your example. Satyaji, any questions from you?
No, sir. Actually, I joined late today,
Okay,
so
no problem.
we'll see the
So,
recording and then we'll come back to the
yeah,
next
no
session.
problem, no problem. So, thank you all of you for joining today and taking time for this class. Next class, you already have the syllabus. So, next class, we will again do some things different and similar to this class. But my suggestion to you is there are two important things for a contract drafter. One is reading, another is writing. We have, I have asked you to read a lot because this is the initial stage for most of you. So keep reading different types of materials. It should not only be limited to law, it should not only be limited to contracts. It can be another subject matter that interests you. It can be simple novel, it can be a story, it can be a financial news, but try to differentiate the articles or the material that you are reading. For example, I'll give you two news websites. One is, let's say, Money Control on the financial news. Another is the Ken, Ken. Go and search for this website. They publish some articles which are freely available. I want you to read those articles and differentiate the way they write it as compared to Money Control. Money Control is a website which gives you news about stocks, investments, money matters, and they do it in a very short, concise manner. The information is quite limited, and they have to do it every day. So the way they write it is like bullet points. You can list out the article in bullet points, and those bullet points are something that they're giving you day in, day out. So the quality of writing that they're doing is far more simple. And if you look at the articles from Ken, they do the analysis of, let's say, certain event or transaction relating to financial market, or let's say if there has been a news or there is a new development. So in the first two paragraphs, they provide a summary and then they go on to discuss. Some of these maybe during the trial period will be full articles you can read. But after some time, I think becomes paid, so you may get limited access. But even in that summary, you will understand the flow. So when you become an in-house counsel, or even if you are an outside counsel, it is not only the contracts that you are doing, you are also doing communications relating to contract. So if there is a dispute, then you have to write a letter. Those letter to the other side will be making an allegation or claiming something from the other side, or it can be something that they have claimed and you have to defend yourself. So these communications are also a important part for a contract drafter. These have to be structured, logical, concise, and as a lawyer, you have to think what should be included, what should not be included. So when you read the difference in the news items or the articles or notices or legal documents or contracts, you will learn many things. This comes with lot of experience. Nobody is perfect every time or every day. Even the most experienced ones can commit mistakes. And there have been instances where a silly mistake, for example, not putting a proper comma, have resulted in a huge fine or loss for a company. And that contract was drafted by a big law firm in USA. It's known as a comma case. Read about that. So this type of knowledge will come when you read different from different sources. And next stage is writing. So I suggest that you also start writing. Write a story, write the events of your day, write anything that you have read, start a blog, start a journal, start a diary, but do some writing daily. It can be anything because going forward, I'll be asking you to write. So these will be some kind of assignments to you. It can be a related topic on contract law, it can be on unrelated topic. But what we are going to do is we are going to discuss how a writing of a particular student is and how it can be improved. There are some good books also on improving your writing. So I'll suggest those books. You can buy them if you have the financial capability, or there are other means to get access like from library, from internet and all those sources. So make sure that you also read these books on writing. So they will also help. So see you in next class. If you have any questions by that time we can discuss that, and keep attentive on emails and also on the telegram group. There is another group on contract clauses. I think there is a link in the intermediate group also, so you can go through that. So I'm trying as often I can to discuss some clauses. So you will learn from that also. So hopefully your learning exercise will be better than mine because you are getting the opportunity initially in your career to have this kind of learning, which for me it was quite late, but I hope you can improve. I have not deleted any groups from Telegram. There are mainly there is a one common group from which you all came, and I created a specific group for intermediate class students, and I have created a new group which is only for contract clauses. If you are unable to see in the main group that initial was there, then it may be because recently I have switched from the general discussion mode to a topic, structured topic wise discussion. And if you want to find out more, just go in Telegram and type help. So there is some issue. Uh, if you want, I can show you. Just give me a second. Hopefully, if I have not switched my Telegram.